So good evening, everyone. Welcome to everybody who's here at Garden Court Chambers, and welcome to everybody who is joining us online. Thank you so much for coming and for joining us. And we celebrate World Children's Day today. This evening is about thinking about building a community of child specialist lawyers. So it is a huge pleasure and a privilege to welcome this evening to very esteemed speakers who've given up their evening to share with us some insights. Leslie Thomas is going to be speaking to Aika Stephenson about her career and how she has become a specialist in representing children in criminal cases. Professor Leslie Thomas KC is a member of Garden Court Chambers, and he's a leading expert in police and other claims against police and other public authorities, against corporate bodies, with expertise across the full spectrum of civil wrongs, civil litigation, human rights, data and privacy claims. He's established himself and is well known as an expert in all aspects of inquests, public inquiries, having represented many bereaved families, in particular where there has been abuse of state and corporate power. And Leslie is currently Professor of Law at Gresham College, delivering his lecture series, Hard Choices, the Law's Struggle and Ethical Dilemmas. And I can share a little anecdote that I was lucky enough to be travelling by plane recently, and I click on the British Airways in-flight entertainment, and Leslie's reputation is now international, so it's very appropriate on the day that we are celebrating World Children's Day that Leslie's expertise is flying around the world on British Airways in-flight. And with similar international critical acclaim, we're joined by Aika Stephenson, and Aika is co-founder and legal director of Just for Kids Law. She founded Just for Kids Law alongside Shawnee Lamb in 2006. And really, it's important just to think about 2006 and what it was like for representing children in the youth court at that time. There was little recognition and understanding, as we have now, of the importance of exploring the background of the child in terms of understanding their needs, exploring the boundaries of whether a child was fit to plead or stand trial. And Aika and Shawneen were really at the forefront of pushing those legal, the legal boundaries of understanding the needs of children at that time. And they founded together Just for Kids Law, and she has gone on to lead the legal team there. She is a solicitor by training, and we'll hear more about her background and how she became a youth justice expert this evening. She is particularly experienced at representing children and those with special educational needs. And since 2017, Aika has led the organisation's criminal work, and she has been recognised for her expertise by the Legal Aid Lawyer of the Year Awards, not once, but twice. And we'll hear more now about her work.
Aika, welcome. What an introduction. I've got to start by asking you this question. What do you love about your job?
Working with young people in the police station or in court, I think everyone knows there's always a long list of things that I have to do in a day that don't get done, because what I will always do is prioritise being with that young person. So if I can meet a family for the first time at the police station, for example, and see that they're really daunted and scared by the experience, and then take my time to do my level best to make that be, an easier experience, and then come out of the police station and see the relief on their face. I think that for me is the best part of my job, and it still keeps me going.
I can see the satisfaction that you get out of that. I mean, see, most of us lawyers, often it's really difficult to get across to, adult clients what they're in, the difficulties that they have. And I can just see that being multiplied so many times more when you're dealing with, a young person or a young person with special needs. So tell us, What skill sets do you think you need to be able to communicate with young people?
I think you need to be friendly, first and foremost. You need to be, you need to have an appearance of being friendly, even if it's not your natural predisposition. And you need to care about what you're trying to do, what you're trying to achieve. You need to be able to create a connection with them, because lots of young people will take you at face value, and they will make a decision very early on.
Trust is important, isn't it?
Yeah, they will decide very early on as to whether they think you care about their case and the outcome for them, and that's really essential in terms of sort of engaging them initially. And then you need a lot of patience, and you need to be able to remember what it was like to be 15 or 16, even if you can't place yourself in their circumstances. I think just trying to remember your inner child is really important, and how that might govern the decisions that they make or the things that they say.
Let me take you back. I want to take you back to when you were 14, 15, 16. When did you decide, this is what I want to do, I want to be a lawyer? And what made you go down that route?
Well, initially, so the first time I decided I wanted to be a lawyer was when I was about 10.
Wow.
And that was when my dad went to prison. He'd been a couple of times before, but it didn't really impact me. But when I was 10, I very clearly decided that I wanted to be a lawyer and I wanted to get him out of prison. I watched a lot of LA Law and Ally McBeal.
I remember Ally McBeal.
So, you know, I had sort of, a romantic idea that I could get him out of prison. And then when I was 15, he went to prison again. At that time, me and my sister were living with him. So it had more of a significant impact on us because he was our primary carer at that time. A social worker came to see us and basically assessed our life skills as pretty good, because we'd been taught very well by a Jamaican man to look after ourselves, which meant, you know, washing, cooking, cleaning. So when he came to the house, it was very, it was in good order, and we knew what we were doing. So he actually decided to leave us there. And so, I was 15, my sister was 17, and we were living by ourselves. So that our house became the kind of go-to for many of our friends in trouble. And so I think that was really when I sort of got a real understanding of the agency that a young person can have in their life because of all the experiences of that time. And then sort of fast forwarding a few more years, I still hadn't quite worked out that I wanted to represent children in the criminal justice system.
When did that kind of...
That happened when I took a job at Felton Young Offenders Institute as an advocate for a remand project that was Children's Society project. And within a couple of days, I could see the change in young people when they came into custody. So they'd be initially very, very vulnerable, and then within days they almost were wearing a mask. So I thought that was extremely damaging, and we were just teaching children to detach from themselves.
Right.
And so that was when I thought youth justice is definitely the thing that I wanted to do.
Tell me this: we all have really, really difficult cases, or cases where if we could do them again, we would take a different path because we've seen real injustice. Tell us about a case that you've been involved in a young person, where you've seen a real injustice and you know why, what happened.
Oh gosh, I can't think of one specific example, but sadly, what I see children who are being prosecuted when they shouldn't be, and children being criminalised.
What sort of cases?
It can be anything from, you know, I've had a child who threw a water bottle on top of a bus at another and was being prosecuted for
So
common assault.
typical childhood prank?
Yeah, and a lot of I mean, there has been a change in that there are less offences of sort of general sort of what you'd consider antisocial behaviour that we're dealing with as criminal lawyers, but there is still every now and then something that would be considered normal childlike behaviour. So I had a case of burglary in a school because two young boys were walking home and on a Saturday, and one of the boys said, "Oh, this is my old primary school," and so they went in and they were playing football in the playground, and then the boy said, "Oh, actually, it looks like it's open. I'll show you around." And they both took off their football boots and put them outside, and went in and walked around the school. Now, obviously, they didn't want to get the school dirty. It was a clear indication of their intentions. But it set off the alarm, and because of that, the head teacher had to have a crime reference number created because she had to inform the security and the insurance, and and it's just ridiculous.
Spiraled.
Yeah, and it spiraled, and it's not to say that so eventually, I think they were dealt with by some kind of community resolution, but to me, it's like it can be the tiniest case. So obviously, I deal with lots of serious cases.
And I suppose, just given that example you've just given, you have these two youngsters pushed into the criminal justice system, and everything that means, impacting their lives for what I would describe as the sort of thing I would have done. Probably at that age, go past your old school and have a kickabout with a ball in the school grounds. Yeah. I suppose let me ask you the converse of a question I just asked you. I asked you about difficult cases. We all also have cases that we're really proud of, where we feel that we've really achieved something good. We've achieved some justice. Tell us about, a moment for you where you feel, my goodness, justice was done here.
This was actually a case that Johnny worked on, mainly I just happened to be part of, but I think it's the one that I'm reminded of most frequently in my work, and that was a judicial review that was taken to ensure that 17-year-olds could have appropriate adults in the police station.
And just to be clear, if you've got children, 17-year-olds are children at police station, that should be a given.
Yeah, but unfortunately it wasn't.
So what was the situation before, and what did you do in your case that impacted on that situation?
So up until so previously, you could have an appropriate adult as a right if you were 16, up to the age of 16 in the police station. 17-year-olds were in this kind of anomalous space where they weren't adults, but they weren't being considered as children. And so we had a young man who'd been arrested for robbery, and his mum didn't know where he was. She'd reported him missing, and he didn't have the ability to inform her of his whereabouts. And the police didn't inform her because he wasn't entitled to have an appropriate adult. And so the following day after he was released, they got in contact with Shawnee and said, "Is there something we can do about this?" And that was really the beginning of a whole host of cases, actually, that formed a campaign called Still a Child at 17. So
was this one of several cases that was kind of like a test case that went on a judicial review?
Yeah, that was certainly the beginning of sort of a whole.
And when you took this judicial review, what did the administrative court say? And what was the and why did they say? Just tell us about the decision itself.
Well, essentially, it was not compatible with the UNCRC, because clearly every child, children are under 18 and should be recognised as such, and so the PACE wasn't compatible with that.
Because it had this grey area about 17-year-olds.
Yeah. And so I think in terms of impact, whilst I didn't directly I did small bits of work on that case, and it was primarily Sean's case, and then a larger campaign by other lawyers that have worked in the strategic litigation team at Just for Kids Law.
And I suppose it's really impactful because
because every time I represent a 17-year-old who has an appropriate adult sitting there, I think, wow.
Yeah.
And so I think that's why that case always
amazing, fantastic.
Sticks out for me.
I can tell you're really passionate about what you do. Tell us why you set up Just for Kids Law and how that came about, and what, because you obviously saw there was a gap. So both of you decided, look, that we need to plug this gap. How did you go? It just amazes me that you went from scratch, saw this gap and filled it. Tell us how you went about doing that.
Well, I was working, so I couldn't see in the law that there was anywhere that you could actually practice and represent children. So after I left Feltham Young Offenders Institute, I started working at Westminster Youth Offending Team, because that to me was a place where you would have direct contact with children in the criminal justice system. So my job was to assess children as a bail and remand support officer in court a couple of days a week, and then supervise them directly on the programme as their bail package. And whilst I was there, I met Shawnee. So we had a client in common, and she saw me arguing with my manager about his vulnerability. And then that kind of got us talking.
Right, so over a cup of tea afterwards.
Basically, pretty much. And that's where we she, I told her that I'd been to law school and was looking for a training contract, but couldn't figure out how I was going to specialise. But also at that time, I have to mention Mel, because Mel was also a solicitor there. The only other solicitor that I regularly saw at West London Magistrates Court, who appeared to, like her clients, have an interest in working in a specialist way with children and young people and building relationships. So Mel had a relationship with the whole family that I'm sure she still does back then. And so I think, it was seeing lawyers working in that way that really made me think, this is something that...
But how did you go about coming up with the idea, the name? Tell us about that.
Yeah. So my youth offending team kind of, I could see from that practice that there were a lot of things that were outside of the remit of the youth offending team that really should have been. Shawneen had come from doing death penalty work in America, and I think there are lots of projects in America, like Juvenile Justice Project of Louisiana. There's actually quite a lot of innovative and inspiring work there. So I think that her mindset coming back here to practice and setting up a small youth team at Lawrence & Co. So it was kind of a meeting of minds. It was me feeling like there were multiple other things that could be done. And Shawneen, with her unique view of how we could practice. It was just a coming together, really. And then there were other people like Emily Bolton, who set up Appeal, who was very integral in sort of the strategic thinking. There have been lots of people along the way that sort of, and so, I think we just felt that there were multiple needs that our clients had that weren't being met, and that the unique relationship that the lawyer has could be extended to work in a much more holistic way.
Has it been an easy journey?
No, not lately. It has its ups and downs, but I wouldn't change it. Yeah, as much as I was saying to somebody today that I'd quite like to work in Waterstones, but so there are stressful days.
Tell us about some of the stresses. We in legal practice, you have problems about funding, problems of, sometimes you have difficult clients, you meet horrible judges, sometimes your opponent, share with us some of the typical stresses. So You're making this look like a walk in the park.
I think, you know, the most stressful things are those imposed by the system itself. I think it's, you know, being forced by a court to rush a case when you know all that you need with that young person is time.
Right.
It's, you know, not being given enough disclosure when you know that there are other things that are there that might assist your client, but you just can't quite get there. And also, you know, when you know that a client is running the wrong case, when you know you've got some kind of idea what the truth and the reality is, but you know it's things like, you know, it's decisions that they're making then that are sort of typical decisions that a child would make about sort of peer pressure or what you might look like or snitching or that are going to affect their future, and you just can't, and not being able to.
That must be really tough.
Impact that, yeah, and not be able to change the course of that or their thinking, and it all just kind of snowballing.
I'm coming to the end, but what I'd like you to share with us, if somebody wants to follow in your footsteps, this is the path that you've trodden on, what advice would you give, you know, young lawyers who want to work with children, young people? What advice would you give them if they wanted to follow your path?
Probably the first thing I would say is just throw away everything that everything that you've been told in your training about how to be a lawyer.
Really interesting.
I think would be the starting point. You can't really practice at arm's length when you're representing children. There's a lot of talk about self-care and boundaries, and you know, obviously you need to. That's important, but you just can't practice at arm's length when you're representing children. And so I think, and you know, what is considered professional and what's not. I think, you know, you need to be able to go with your gut, go with your instincts, and think and remember what it was like to be 15.
Really important advice. Thank you. Thank you. Let's give a...
Thank you both. So we're now going to have a panel discussion, and so we're going to say thank you very much to Leslie, who has a very jam-packed schedule and has to rush off now, and we're going to be joined by the remainder of our panellists. So thank you, Leslie. What I learned most of all is just the passion and the commitment that Aika brings to the role. And so it's a huge privilege to be joined by this really impressive panel. I'm surrounded by people who I admire and respect, and have really blazed a trail in terms of thinking about children's rights in a criminal justice context. So we've heard about Aika and her background and how she brought her expertise from working both from the views inside Feltham to working in the Youth Justice Service and then becoming a lawyer. She and Shawneen set up Just for Kids Law. Shawneen is both a barrister and in England and Wales and an attorney in the USA, and as you've just heard, she worked on death penalty cases and really innovatively saw the different way that children could be represented and brought that back to her practice in London, where she was one of a few lawyers who were saying, look, we've got to have a separate youth justice team. We don't just have a generalist criminal team, we have a separate youth justice team. And then went on with Aika, as we've just heard, to set up Just for Kids Law. And she since then co-founded Impact Law for Social Justice, a consultancy that supports those considering using the law for social change, which she herself has done on many occasions. And prior to working in the UK, Shawneen worked at the Louisiana Crisis Assistance Centre, representing those facing the death penalty, and helped Clive Stafford Smith set up his NGO, Reprieve. For her work, Shawneen has been awarded the Eisenhower Fellowship and a Ashoka Fellowship, Shackleton Fellowship, and a World Economic Forum young global leader. And if that wasn't enough, she also is now the director of the Youth Justice Legal Centre, we'll hear in a moment. We're also joined by Dr. Laura James, who's a consultant solicitor. She is a sister. She is solicitor, member of the Law Society's Criminal Law Committee and a trustee of the National Association of Youth Justice. Laura is a consultant solicitor at Scott Moncrief and Associates, and is also a consultant solicitor at GT Stewart Solicitors and Advocates. She also finds time, and I don't know how, to teach at South Bank University in their law department, and she was awarded a professional doctorate in youth justice by the University of Bedfordshire in 2014. She's a board member of the Legal Aid Practitioners Group and trustee of Hammersmith and Fulham Law Centre in her capacity as a counsellor for my local borough, Hammersmith and Fulham. She's a trustee of the National Association of Youth Justice, a committee member of the Association of Prison Lawyers, the Mental Health Lawyers Association, and the Criminal Appeal Lawyers Association. And she now sits on the Law Society's Criminal Law Committee. She's done all this, having also been at the Howard League for Penal Reform and was its legal director between 2016 and 2022. So we're hugely privileged for her to bring her expertise to the panel this evening. Next there is Mel Stooks, who's a partner at GT Stewart, and she qualified as a solicitor in 1998, and as you've heard, was one of these innovative solicitors practicing as a solicitor and really choosing actively to specialise in representing children, defending young and vulnerable people. She's got a particular specialist interest in autism and regularly receives referrals from the National Autistic Society, and she works with other professionals to ensure that clients can effectively participate in their defence and navigate their way through the criminal justice system. She's an experienced trial advocate in the youth court, and I think probably is one of very few solicitors who have really chosen to specialise as a trial advocate in the youth court. And for that, we will learn more in a moment. She's defended young clients charged with the most serious crimes. She also somehow finds time to, alongside that busy practice, provide training in youth justice to other professionals, including appropriate adults required to attend the police station. And she also runs legal advice clinics at London youth clubs. And finally, I'm joined by a fellow member of Chambers, Elena Papamichael, who is a crime and youth justice specialist, and she's regularly instructed in complex and serious cases representing children in the Youth Court and the Crown Court. She co-authors the Youth Justice Update for Legal Action and has also worked on a youth justice research project for Newcastle University and the Youth Justice Legal Centre. She has worked to develop the youth justice assessment for pupils in Chambers, and her practice has a particular focus on racial injustice in her work, and she was on the advisory board to the Racial Bias and Bench Report. She was previously the chair of directors at Forefront, a youth justice and racial justice youth-led project, and all of that belies the fact that I've seen her advocacy, I've seen her written submissions, and she fights incredibly hard for both her child clients and also young adults, and her forensic analysis of the case gets unbelievable results for her clients. And so I'm really delighted she's been able to join the panel this evening to share her expertise, to talk about being a child specialist criminal lawyer. So I might start by asking the panel a question about why they've chosen to specialise in representing children, particularly children in criminal cases, because one of the anecdotes you often hear at court is actually lawyers don't want to represent children. They find them challenging clients and they seek to avoid it. And they're the most vulnerable clients, I would say, in the criminal justice system. So why is it that you've chosen to represent children And Mel, I'm going to ask you that question.
I never intended to be honest. I was lucky enough to be offered a job as what was then an outdoor clerk at a firm that unusually had a solicitor who had chosen to specialise in representing children, and she kept sending me to the Crown Court to look after her clients because I was the youngest employee and therefore meant to be able to relate to them. And I had a couple of rocky days where I didn't like the first two, and then I met somebody who was, quite frankly, the best company I had come across in a long time, both socially and professionally. And from that day I was sold, and it wasn't very long after that that I crossed paths with Aika at West London Youth Court, because by then I had, I was just invested in how these children really didn't need to be dealt with as mini adults. And unfortunately, meeting Aika meant that I had a very high bar of what I expected from everybody else, because as Shauneen has referenced and Kay has referenced, she fought a lot for the people that she was looking to get bail and remand for. And it was when you meet other professionals that make your job so easy to fight for your clients as well. It was just like, yes, this is a team effort, and that's why I became quite invested in it.
Would anybody like to give some examples of why representing children is different to representing adult clients?
Well, I mean, I've heard so much already. It's just, completely different experience. I also started my legal work as a clerk, often doing cases with very old, entrenched clients who had long criminal careers, and that's what I thought doing crime looked like. And until I started working with children, you learn so much. You have a lot of fun, definitely, and it's completely, you have an opportunity to make a huge difference to somebody's life, and that, I think, is a really special privilege of representing children. But it does mean you have to take a completely different approach, doesn't it? You've got to take time, and you've got to slow down, you've got to invest, you've got to work at it. Sometimes, I think what Aika was saying earlier about, young people can be quick to judge you, and so you always have to be on your best behaviour in a way. And it's hugely rewarding and brilliant, but it is intensive.
Thank you. Shauneen, did you want to add anything to that?
No, I think the only thing when Mel was talking it's about why kind of young people, and when I was in the States, the reason I got into this work was because they still had the juvenile death penalty, and I had a client called Ryan Matthews who was innocent of the crime that he was accused of, and then was sentenced to death and spent 5 years on death row before he was exonerated. But it turned out the only thing he did that enabled him to get convicted of this crime was that he was stopped with his co-defendant, Travis, who wasn't allowed to mix with as part of his supervision requirement on a juvenile case. And so when the police stopped them and asked his name, he gave a false name. And so solely on the background of that, and that's literally a child's mind, isn't it? It's like, I am not allowed to be hanging out with this other child, so I'm going to give a false name to get myself out of it, without being able to see the consequences of where that might end up. And I think many times those of us that have represented kids have seen why the children don't want to tell the whole truth in the instance to an adult they don't know and don't trust, and have no idea what the consequences can mean for them. And so often we have to front load that work and anticipate all the possible consequences to explain to children what might happen and why it's really important that they tell us everything, against all of our instincts, I think, to tell a stranger everything. So yeah.
That's a really helpful example of how the tension is between representing such vulnerable young people when their brains are still developing, they act impulsively, and they're driven by these immediate needs, can't think about the future consequences, and they need their lawyer to do that for them. And with that, I think what I'd like to do is turn to Laura who, and usually on this panel of criminal specialists is actually particularly a specialist in prison law. But you see children who have generally been convicted and they've received a custodial sentence. So that's quite a unique perspective. And what do you see is happening when children aren't represented by specialists? What do you see has gone wrong?
So just to give a bit of context, my specialism in particular is with child lifers, so children who've been convicted either of the old IPP sentences or discretionary life sentences or murder. We still obviously have the mandatory murder sentence here, life sentence for murder. So it's the sharp end of the wedge, but also it's typically some of those cases which, you know, are seen as kind of quite desirable, unfortunately, by general practitioners, and so they don't always get specialist children's lawyers. And it's quite interesting for me that quite often with that passage of time, when I come in, and it might be for all sorts of reasons, maybe they've got a prison discipline problem or they've got some mental health problems, and I might come in and then see that actually, just picking up on what you're saying about Mel, that this young person's clearly got traits of autism and yet has not even had a psychiatric report before being given a discretionary life sentence. And in fact, there was one particular case where that sort of leapt out at me. I came in after this child had been given a life sentence, and it was so clear to me, I also practice as a mental health lawyer as well, that he had many autistic traits, and that was directly relevant to his culpability as well, actually, but certainly to the sentence. And in the end, I was able to get an independent psychiatric report. He went to hospital. He was really struggling in prison because of his autism, which was undiagnosed and therefore untreated. And we had managed then to go to the Court of Appeal and get his life sentence switched for a hospital order. But it was just amazing to me, and it was amazing to his family as well, because everything suddenly clicked into place once he had this diagnosis. For him, his family, you know, his whole childhood, the way he'd been interacting or not interacting suddenly made sense. And he was able to start to get the help he needed and flourish. But there's been so many times over the last 20 years where young people have not been diagnosed with quite serious issues that they could have had help and support with, and they've been criminalised as a result or suffered severely as a result. So I think for me that's a really critical thing.
So if you had a magic wand, would you make sure all lawyers representing children did?
Well, I can't answer that question without saying that, you know, we do live in the real world, and lawyers representing children need to be paid properly, and they're not. Criminal lawyers aren't paid properly at the moment, and so that's the caveat to all of that. But I spend a lot of time locked in rooms mainly now with young adults who were sentenced as children, going through pre-sentence reports as we're going towards their parole hearing. And they say, I never said that, or I didn't mean that. I don't know where they've got that from. And I think we're really conscious about making sure that a child's understood us. Well, we don't make as much effort to make sure we've actually understood what child is saying and that we're probably properly listening. And the other thing, I think, this morning, myself and another colleague from GC Stewart went to see a child that we've both been working with for many, many years. And I'm doing his parole work and she's doing a criminal matter for him. And for the first time, we've both been working in parallel with this young person for years, but it was the first time we actually went together. And we were joined up, and he wasn't having to repeat himself. We were making sure that the work we each do complements each other and we're not undermining each other. And he's not having to repeat himself. And I really think, as you know that vulnerable and disadvantaged children have multiplicity of needs. And that means, because of the way our ridiculous legal system works, they have loads of different lawyers. And we actually need to take more responsibility about working together more closely and taking some of that burden. We shouldn't be expecting a child to have to tell their criminal solicitor what their family lawyer told them or their community care lawyer told them. We've got to actually, as adults, take a bit more responsibility and work together more closely.
Really helpful. Thank you, Laura. So turning from that holistic working, I was going to turn to Shawneen. Jornine and Aika set up Just for Kids Law, but then went on to set up the Youth Justice Legal Centre. And perhaps you could give some context to why you set up the organisation.
Yeah, definitely, and thank you to Kate who led that for many of its kind of key years. I mean, I think the thing that was obvious to both Aika and I was that you would never let a teacher into a classroom without learning how to work with children. And in the medical profession, you qualify as a doctor, and then it's 6 additional years before you become a paediatrician. Yet when these kind of crucial times in children's lives, we feel that there's no need for specialisation. It seems not just ridiculous, but punitive to those children that they don't get specialist lawyers. So I think the Youth Justice Legal Centre's aim is to train and educate all professionals on how to be a specialist youth justice lawyer. But it's not just that, is it? There's skills that are working with children that are required, as well as the black letter law. And so those are the things that we try and teach. When Aika was talking about, I will remember what it was like to be a child. We've just developed some materials for the Child Law Network, and one of those icebreaker trainings is what we're calling the empathy experiment, where you ask the attendees to remember a particular point in their childhood where they did something wrong and who were they afraid of. And normally it's a parent or a teacher, and it's not the criminal justice system, but we all have times in our life where we were trying to hide something we did wrong from someone that had authority over us. And for kids, the people with authority over you are every other adult. And we forget that the further we come away from childhood, because we're autonomous human beings. And so I think it's just important, those little pieces of work, to take judges back to what it was like. Everyone's been a child, that's what universal, everyone's been a child, but often we forget what it feels like. So I think things like that are really important. The point that Laura made about making sure children understand us. It's really hard to understand the legal system if you're an adult. As you know, as Leslie was saying, most adults can't. So how do we expect kids to understand what's happening to them? It takes a special skill to do that, and everyone in the panel, and I'm sure in this room, have developed those special skills, but perhaps just through their work, the way they've worked or the way they've been trained, rather than curriculum that they can go, yes, I know how to do that, I know how to do that. And that's what I think we really want to see a change in.
And as part of your work, you published a report earlier this year called It's Lottery, about the state of advocacy in the youth court from solicitors. Do you want to just...
Yeah, so I think this was a follow-on report as a report that you work with ICPR on, Kate, about what is the quality of advocacy. So some children will get specialist lawyers and it turns out they're really lucky, and others just won't. And what I really jumped out at me is lawyers don't know what they don't know, which is true of all of us, right? So they go in and they think they know the skills that are required. And it turns out actually there's a whole body of law behind this specialization. There's also a whole body of skills, and they don't necessarily have them. And this isn't just true of solicitors, it's also many criminal barristers. The case that Aika and myself, and I think Laura was involved in, the Court of Appeal, McGill and Hewitt, those guys, the criminal practice directive or the criminal procedure rules were not applied on behalf of 14-year-olds that were on trial for murder. They're set out there in the regulations, but they weren't applied at the most serious of cases with kids with mental health difficulties, neurodiversity. And as a consequence of that case, now barristers have to fill in a tick box exercise that drops down at the PTPH form. But the fact that that's as far as it goes, or that didn't even exist beforehand, and now there are 4 or 5 children that are doing life sentences who were 14 at the time, it's kind of crazy.
Thank you. I don't really want to digress, but I'm sorry to tell you that there is a tick box exercise that everybody should be using in the Crown Court, and unfortunately, it's still not consistently not being used. Unfortunately, but that's our task for tomorrow. For this evening, I want to hear from Mel, because she also set up an organisation, the Youth Practitioners Association, of which Laura is also a member. And perhaps you could just tell the audience about the Youth Practitioners Association if they don't know about it already.
So the Youth Practitioners Association was set up because there are a smallish group of us who have specialised in representing children in the youth court. And Leah Connolly from Song Macmillan, Claire Dissington also from GT Stewart, and Caroline Liggins from Hodge Jones and Allen felt quite strongly that we had a lot of experience of boots on the ground, so to speak. We know how the courts work, and whilst there's excellent training in relation to the law and how to represent children, some of the very real problems that we have in our local courts are something that need addressing and need discussing. And it was a means of ensuring dialogue between different professionals who go to these courts. It involves barristers, youth justice workers, and it became an information sharing project as well as providing training. And we do provide training on a variety of issues, but it's much more practical. So, for instance, one of the issues that's come up recently is communication in the courts, and youth justice workers have started using speech and language passports, but this isn't a particularly widely known piece of information. In fact, it only came out at my local court due to a user group meeting. And they were like, oh yes, we have a lot of the boroughs at my local court have these on file, but it didn't occur to them that it would be of any use to the youth court. So having already campaigned on my, much to my local youth court users group irritation, I'd be campaigning for extra training in relation to communication. And I was just like, but hang on a minute, we have these documents, why aren't we doing something with them? And so it's now become more widespread practice for the youth justice workers who know that their child has a speech and language passport to ensure that it is provided to the court that is dealing with the hearing in advance of the hearing, so that the court can adapt that hearing to that particular child's need. So that's one of the most recent pieces of work that we've done as an example of practical knowledge that we've been able to translate into wider use.
Thank you. As Shawnee said, I did work at the Youth Justice Legal Centre, and I remember when we were setting it up, we were looking at sort of comparative examples in other areas of the law. And in family law, there is a specialist accreditation and a children law panel. So the expectation is that you do this additional training, you demonstrate the competencies by putting together a full portfolio, and that is the standard to which solicitors are expected to reach before being involved in children law cases. There's not currently an accreditation in youth justice or for child criminal lawyers. What do you think an accreditation or some sort of specialist panel could achieve?
I think it goes back to what Shawneen said about you don't know what you don't know, and the expectation that people would fill their own gaps in knowledge is perhaps a little vague to ensure that children have the best representation. As Aika said, they make their decisions about you very quickly, and the fact that you know you're being represented by someone who has been accredited would, I think, put their mind at rest a lot quicker than having to judge you while you muddle through. They know that they've got a specialist lawyer, and therefore it must be better for them to cooperate with them. I mean, exactly as Laura said, we live in the real world. Money for accreditation is not really there. Perhaps accreditation could achieve better funding for the youth court work, particularly things such as the trial advocacy, which takes so much longer to prepare and to do a trial for a relatively straightforward offence as opposed to in the magistrates' court. And that's what I would hope accreditation could achieve, but I do realise that practically and financially speaking, it might not be as viable as we'd hope.
Well, we can hope, and there is about to be, I think, £5.1 million, which has been promised in 2024 to funding in the year, is likely to see an uplift in all cases. Aika, having heard that, we've talked about what accreditation could achieve, particularly for solicitors. Now, the Bar Standards Board several years ago introduced a requirement that barristers practicing in the youth court had to register to do so, and by registering, they were registering that they had met the youth proceedings competencies, which came out of a piece of research that the BSB had commissioned. Have you seen an improvement in the training of barristers since that was introduced?
The problem is that it's you're grading yourself. So I think it's very weak. If I'm being completely honest, I think it's really weak just to ask people to say, oh, can you do this? So the starting point for a lot of people is, well, do I want to have the full range of, full range of cases? Do I want to be able to take on the full range of cases? Yes, I do. So, I need to tick these youth competencies. That's not good enough for me, as far as I'm concerned. It's put a spotlight on it, and it's sort of made solicitors' regulatory authority start to think that, they need to do something, and they are making steps in that way. And I know that's a lot to do with your work, but it's just really weak. It's not good enough, and I don't think so. I don't think so.
And so do you think there should be an accreditation?
100%.
Thank you. I'm just going to now turn to Eleanor. So we've heard Aika saying she thinks there should be accreditation. We've talked mainly about youth court work. You practice regularly in the Crown Court. So have you seen examples in the Crown Court where the absence of having an accreditation, the absence of a requirement to have specialist knowledge, has resulted in worse outcomes for children?
Yeah, I mean, when I started thinking about today's talk, I was going through the different aspects of the criminal justice system, and pretty much every layer is different when it comes to youth justice compared to adults, and it can be quite fast developing. So there has been recent changes, significant changes, for example, to bail, changed in 2022. And so at the moment, unless you are a barrister who has a special interest to go and get up-to-date training and education, you are not necessarily going to realise that there has been those changes. And so, I mean, a really stark example is the case of ADG, which came out on the 8th of November. And that involved two youth defendants who were 17. They set out the Section 45 defence in their defence statements, the modern slavery defence. They were both in care, they were both vulnerable. One had a learning disability. When it came to giving the directions to the jury as to what the Crown had to prove in relation to the defence, he sent round his directions to the prosecution barrister and the two defence barristers. Nobody complained, and he actually directed the jury that they had to be sure that the conduct was as a reason of compulsion, or that may have been the position, when the statute clearly makes clear that compulsion isn't an element for youths. So that was one judge, one prosecution barrister, two defence barristers, however many CPS solicitors who had reviewed the case and defence solicitors. None of them spotted that the direction was wrong. Certainly the one with the learning disability, if not both, also had an additional defence under Section 3 in relation to exploitation. So the jury were only directed in relation to threats. So I think that's quite a shocking and upsetting example of how wrong it can go. And what's even more upsetting is there was a really, really similar case in 2022 in NHF where the same thing happened. So this is not even just a one-off, this is routinely happening. And how many cases is that happening where nobody thinks to appeal it, so it doesn't end up getting corrected? So that's an example. Another example, just practically from my experience. So I was in court in the Robing Room the other day. There was a barrister that was about to represent a youth for sentence, and he was, I can't remember if he was speaking to another defence barrister or prosecution barrister, but he said he'd read ZA.
Just for the benefit of the audience, if you don't know the case of ZA, it's a recent sentencing authority.
I can explain it quickly, yeah. It was youth defendants who were being sentenced for a conspiracy to rob. At first instance, they received 5 years, and then on appeal, the Court of Appeal held that they, there was criticism that nobody referred to the youth-specific robbery guideline. The judge at trial jumped straight to the starting point in the adult guidelines, and they received 5 years custody. And then on appeal, the Court of Appeal held that they would have been suitable for a YRO with ISS, but because of the time spent on remand, that would have been overly onerous. So the court imposed 3 years, which allowed for their immediate release. This barrister had obviously skipped to the end or misunderstood. And so he just really blasely said, "Oh, well, they after all of the fuss in that case, they got 3 years anyway." And he was about to walk off and represent this young person, and I stopped him and I said, "Sorry, no. The court only imposed 3 years because of the time they'd spent on remand, but the judgment said that they should have received a YRO with ISS." And then he sort of sneeringly said, "Oh, do you spend quite a lot of time in the youth court then?" As if that was not embarrassed, not just like, yeah. So that is, so I think that it is routine probably that there are really serious failings on behalf of barristers in relation to representing young people in the Crown Court, and especially because it's not, I guess, every day that they're representing young people. This kind of thing happens, but when it does happen, the consequences are really, really bad.
Thank you for sharing that, and it is worrying, and the case of ZA troubled me when I read it, and it troubled me because it was a judge in the Old Bailey with Treasury Counsel who would have had a junior and an instructing solicitor, and I think there were the 3 co-defendants, so that's another 9 lawyers involved, and none of them were able to take the judge to the child-specific sentencing guideline, which, as was said in the judgment, takes a root and branch difference of approach to how you start the sentencing process, and has a completely different outcome for children. And actually, I do this day in, day out, and I bang the drum for the importance of training criminal lawyers, and hearing those examples is quite shocking to hear. But it's particularly shocking because in the Crown Court, the cases that are heard are the most serious. It is children charged with murder, attempted murder, Section 18, and possession with intent to supply, those sort of offences. So there's the consequence of poor representation of their spending years, and simply years, in custody. So I guess I probably know the answer to this question. There are relatively few cases in the Crown Court. We know there are around 570 trials. Of course, that won't always result in convictions. Some children will have pleaded guilty, and there are around a similar number of sentencing occasions. What do you think, if there was accreditation, should it be a mandatory requirement?
I do think it should be a mandatory requirement, because I think otherwise it relies on barristers having a particular, I think, interest in youths, and actually anyone that's in the Crown Court might end up with a youth client, and they should be adequately trained to deal with them. I think also on the point of the relatively few number of youths in the Crown Court, I think that there is an increase in the recognition that 18 to 25-year-olds are a distinct group when it comes to the justice system, and they are deserving at least some, if not significant, protections that youths are entitled to. And so I think probably the figure of people actually being failed due to the lack of specialist knowledge is actually far greater. And certainly I represent young adults very, very often in the Crown Court, and using youth specialist knowledge and forcing judges to, I guess, take a gradiently from 18, it should be really very similar to how you'd approach a youth in the Crown Court, and less, I guess, at 25. But that is a really very significant group that I think are also being failed because there's a lack of specialist knowledge in relation to youths. So it's more significant a problem maybe than it seems on the numbers.
And also, of course, given the backlog that many of those children who are, or young people who've turned 18 were children when they offended. Thank you very much. So thank you. Gosh, that was an impressive rattle through of a lot of the issues that that lead us to, I think, just the obvious conclusion that it's just no longer tenable for us to be in a position that we do not have mandatory training and accreditation before you represent children. And certainly when I speak to both children and parents and just sort of interested lay people who don't have a background in the law, they find it first of all shocking that we still have such a young age of criminal responsibility, and that from the age of 10, which that's when children are still in primary school, they are held criminally responsible. But not only that, that you as a lawyer can be allowed to represent a child, in fact prosecute a child, without any specific training in understanding their needs, let alone the complexities of the black letter law. So just before we draw this discussion to an end, I'll allow the audience to have a few moments in case they have any burning questions. But certainly what Aika said in her discussion with Leslie, that when she started out with an aspiration to become a lawyer and really wanted to specialise in representing children, she did not see a career pathway ahead of her. And I think the work that these trailblazers sitting next to me have done has made it possible for there to be a career and to specialise in representing children. But can I ask each of you just to share what advice you would give to a lawyer specifically who was an aspirational lawyer who wanted to specialise in representing children in criminal cases? And what top tips would you have? Can I turn to you first, Laura?
Top tips if you want to be a children's rights lawyer. Well, first of all, it is tough. I think you can, I mean, it's brilliant, but it's tough and you've got to really want to do it. I think that's the first thing, and you've got to know what you're getting into. So I think one of the things that's really important is not just to sort of focus on the law, but focus on the children. I think we haven't talked about language yet today, but I noticed the judgment you just mentioned, Elena, talks about the appellants as 17-year-old men in the second line. And it's a good judgment, obviously, but, you know, and we've got to change the mindset. Say, if you're going to work with children, like I said, it's not an arm's length business. You've got to be prepared to really commit your heart and soul. And that's a big undertaking.
Thank you. Now,
I think I'm going to expand on something that Aika said earlier, which is basically forget everything you learn at law school, bar school. I know you're taught to sound really good in court and you're meant to be impressing the judge, but actually in reality, you've got to learn to speak the language of the child so that they can follow the hearing and do it in such a non-patronising manner that they don't realise you're doing it. But hopefully the people that you're speaking to who are making the decisions realise why you're doing that, and that makes them realise that they're dealing with a child.
think it's quite similar. You're not necessarily going to learn the skills that you need, I think, to be an effective youth justice specialist lawyer. So I guess it's about taking the initiative to get those skills yourself. I volunteered in a youth club for years and years before I became a lawyer, and I think that was an invaluable experience for me to communicate with young people, understand what they're going through. All the things that have been discussed this evening. I wouldn't have acquired those skills through university or even the formal training that you have at all.
Thank you. God, I think you have to be prepared to be fueled by hope. That is sometimes that's all there is. It's the hope in that young person's potential. I know it sounds cheesy, but you've got to be forward thinking, and you've got to be thinking about the impact of a caution, a young person's experience with a police officer, whatever it is. You've got to be thinking about how that's shaping that young person's future in every interaction that you have with them, and that's also in the way that you conduct yourself.
I was noticing when we were talking about the barrister that said to you, Eleni, that you must practice a lot in the youth court, and there was a collective groan, and we understand what that means, that kind of dog whistling from a lawyer that you are practicing in a lesser jurisdiction. Yeah. But I always found it a privilege to be in the youth court. I never found that it was a lesser jurisdiction, and I think when you step outside the kind of snobbery of the legal world and go, well, why am I doing this? It doesn't matter which court you're appearing in, you're doing it for the client. And I think the thing that Aika was saying about the hope, we've got a client that we represented when he was 14 and he got in such serious trouble throughout his teenage years. We worked with his mum, both of us had cases with him. He ended up in hospital, he ended up in prison. His mum was always calling us. And now he's 30 years old and he's a really successful businessman. And every time he opens a new enterprise, his mum sends Aika and I a photo and says, you guys help me raise him. And so there is hope. And that's the beauty. That's why people have kids. That's why people parent. You know, kids are always changing, and the kids are fun, you know, they're fun to hang out with, and so we should see it as a privilege. I always thought it's the luckiest job that I've ever been able to do, so I'm really grateful. And it's true that there weren't always skills out there, but there are now. You know, YJLC provides training to barristers, to solicitors, to youth justice service, and the Child Law Network has now got a broader set of skills for any child's rights lawyer in any area of law in any jurisdiction in the UK. So there is stuff out there and people can go and hone their skills.
Thank you, Shauneen. One of the recent pieces of work that I've been involved in with YJLC is this Dare to Care guide, and I just thought I can resist but give it a pitch, because actually Shauneen is absolutely right that over the recent past there have been a number of resources that have been developed. This one is being co-produced with Care Experience Young People to teach criminal lawyers how to better represent them. And we know that significant proportions of children and actually young adults in the justice system have had experience of care. Really important for the court and those lawyers representing them to understand the context of their behaviour, because quite often having that understanding means that actually their culpability is reduced, and maybe the public interest in prosecuting them either evaporates completely or diminishes to the extent that that prosecution is no longer in the public interest. So there is that guide, and I should, for completeness, also mention that the Inns of Court College of Advocacy are rolling out a training programme for barristers, and they had their first training event on Saturday, and that's a course, an advocacy course, looking at providing advocacy skills for children in conflict with the law. So the training is becoming available, and I think it's worth mentioning before we draw this webinar to a close that the work I've done recently about children is they do they're changing incredibly and maturing at huge speeds in adolescence, and within a couple of years, which might be the length of time between when the allegation took place and when their case actually comes to court, they can be completely transformed, or they can be transformed in a short period of time in the secure estate. And I actually had the privilege of being invited to HMPYOY Warrington to deliver some training last week, and I was told about how much young people, even on long sentences, how much they change in such a short period of time. And that's really worth the hope, the point that Aika's raised about hope. I think is really important, and we need to make sure that the courts sentencing them are aware of that. But while I'm in the presence of such greatness around me, it's also worth remembering that we also know that these relationships that young people have with adults are really important, and lawyers can be the first trusted adult that child has in their life, or at least in the recent past. And so lawyers can make a huge amount of difference if they establish that relationship of trust, if the child believes in their lawyer, and they believe that their lawyer also believes in them, because lawyers are fighting their corner, and there might be a lot of professionals in their life who haven't got their best interests in the forefront of their work. So the work that our panelists do day in, day out is hugely admirable and hugely important at making a difference every day to children who are more likely, as a result of their commitment and hard work, to go on to fulfill their potential in adulthood. So thank you to Laura, thank you Mel, thank you to Eleanor, thank you to Aika, and thank you to Shawneen. And for our external speakers, we've got a little gift to thank you for giving up their time, because not only do they do this tirelessly, way beyond normal working hours, they've given up their evening to come and share their expertise with the audience this evening. So thank you very much. The case that has been addressed online will answer in the chat to you, Shadrach. Thank you very much for asking the question, and I'll draw this webinar to a close. For those of you who are able to stay, we'll welcome you for some refreshments. For those of you who've joined us online, I wish you a happy World Children's Day, and thank you for joining us. Good night.